Good day, Crime Talk aficionados. We have a recap, but not just of all the top stories throughout the week. Well, since all the top stories in the week just happen to be about Bryan Kohberger, here's a recap of all the top Bryan Kohberger stories conveniently located in one location. Thanks for watching. We'll see you next time. And remember, the Constitution matters.
All right, lawyer.
Let's go ahead and get to today's show. Now, last week, we went through a lot of the motions that came out and judges' orders that came out in regards to the Bryan Kohberger case. We had the show on Friday about the family members in the courtroom order. We went through that extensively. All the motions in limine that the court granted, as well as the touch DNA contact order, as well as the motion in limine as it relates to the make and model of the suspect vehicle, as well as the order regarding motions in limine that were granted. But there was one motion that I didn't go through as thoroughly as I should have, and that was the order on the state's motion in limine regarding the neuropsychological and psychiatric evidence. Now, as you know, Bryan Kohberger is charged with 4 counts of murder plus 1 count of burglary in relation to the death of 4 college students back in Moscow, Idaho on November 13th of 2022. Well, you can raise what they refer to as a mental health defense. All right. Basically saying I'm not competent. I have some sort of mental disease or defect. Basically, it's not guilty by reason of insanity. And so the prosecution in this case filed several motions saying, hey, we got these reports about the neuropsychological and psychiatric evidence, Bryan Kohberger. Are they trying to raise this as somehow trying to show that Bryan Kohberger could not form the mental element required, the knowing element of the offense to commit these crimes? Which is a valid defense. You could raise that. The defense says, no. We want to be able to raise these issues because we believe that Bryan Kohberger is going to have some unconventional courtroom demeanor, and we want to be able to explain it. And yes, they're trying to get in there. Hey, he's got these conditions, and so therefore, be a little more lenient on him than he would be with somebody else, right? Tough road to hoe because the guy's in a PhD program. Anyway, so I believe I did not go over this as thoroughly as I did last time because I thought the show was running a little long and I wanted to get to it. But I went back over it again this weekend and I think it's worth going through the entire order. So let's get to it. The order on the state's motion in limine regarding the neuropsychological and psychiatric evidence. Intro. The state seeks to prohibit defendant from offering any testimony during the penalty phase in connection with his neuropsychological and psychiatric evaluations performed by his disclosed experts, Dr. Rachel Orr and Dr. Eileen Ryan. Specifically, the state objects to the testimony proposed in Dr. Orr's and Dr. Ryan's respective expert disclosures, which includes their reports. The state argues the proposed testimony falls outside the mental condition evidence allowed by Idaho Code Section 18-207. Defendant responds that he's not relying on the proposed testimony as a mental element defense under 18-207, noting his relevant diagnosis are physical conditions, not mental conditions. Rather, he intends to present the evidence to aid the jury in understanding both the physical implications of his diagnosis and contextualizing his allegedly unconventional courtroom demeanor. Oral arguments on this matter was held on April 9th, after which the court took the matter under advisement. The court finds that if defendant does not testify, evidence of his diagnosis to explain his courtroom demeanor is not relevant and or inadmissible under Rules of Evidence 403. Ruling is reserved as to certain behaviors that may become relevant in rebuttal, except for expert testimony that he was physically unable to commit the crimes for which there is no disclosed opinion. Standard. The question of whether evidence is relevant is one of law, while the decision to admit relevant evidence is discretionary. On discretionary matters, the trial court must correctly perceive the issue as one of discretion. 2, act within the outer boundaries of its discretion. 3, act consistently with the legal standard applicable to the specific choices available to it. And 4, reach its decision by the exercise of reason. Facts. During the course of this case, the defense team Dr. Rachel Orr, a clinical neuropsychologist, to conduct a comprehensive neuropsychological evaluation of the defendant and issue a report. She ultimately diagnosed defendant with autism spectrum disorder, level 1, without accompanying intellectual or language impairment, ASD, and obsessive compulsive disorder, among other things, and then lists several exhibit numbers. She also listed various diagnoses for which defendant met the criteria in the past. One of these was developmental coordination disorder. According to Dr. Orr, ASD, the autism spectrum disorder, is a complex, heterogeneous neurodevelopmental disorder rooted in brain differences and characterized by social and behavioral features. It causes deficits in which affected individuals perceive and react to others and their environment, causing problems in social communications and interactions, repetitive behaviors, and narrow range of interests. There's a wide range of autism symptoms and severity. Deficits can include a restricted range of affect, atypical eye contact, displaying facial expressions or movements that do not match what is being said, failure to consider social cues, having trouble with speech reciprocity, and repetitive behaviors. While defendant is diagnosed with the least severe form of ASD and by all accounts is highly functioning, both Dr. Orr and Dr. Ryan noted deficiencies in his behavior to include intense eye contact, restricted range of affect, occasional subtle rocking of upper torso while seated, awkward gestures and interaction, atypical tone, lack of appreciation for personal space, and pedantic speech. However, Dr. Orr also observed the defendant demonstrated typical social behaviors such as fairly consistently, though not intense eye contact, polite demeanor, and social conventions, for example, shaking hands upon greeting. She noted the defendant engaged in conversation and was never overly inappropriate. Dr. Orr noted that the defendant manages sensory processing differences by soothing activities like driving and extensive time in the dark. Defendant's OCD is manifested through compulsive cleaning behaviors and taking precautions to avoid contamination, sickness, or germs. He excessively washes his hands and reportedly uses gloves during basic everyday tasks. Although the defendant does not carry a current diagnosis of DCD, Dr. Orr opines that he met the criteria for the diagnosis in the past. She explains in her report. Defendant's educational history, parents' report, and evaluation results all provide evidence that the defendant experienced significant deficits in motor functions in the course of development, which in turn contributed to problems meeting physical, typical, moto, and coordination milestones of childhood. For example, problems catching balls, handwriting, riding a bicycle. While motor problems have not impacted his functioning significantly in many years, the defendant continues to present with impairment in fine motor dexterity and vulnerabilities in visual motor functions, evidence in his cognitive profile and observations of his behavior. The only observation Dr. Orr made with regard to the defendant's fine motor dexterity was the defendant moved his whole arm and repositioned his upper body slightly to manipulate the items effectively. In her cognitive profile, she stated that defendant's visual motor skills were relatively weak in the context of his overall profile, particularly when precision or dexterity were involved. Example, copying, visual motor sequences, consistent with his history of fine motor deficits. When isolated, defendant's fine motor dexterity and speed were impaired bilaterally in the first percentile, likely impacting his visual motor performances as well. According to the declaration of Dr. Jeffrey Lewine, submitted by the defendant as Exhibit D1 to his response to the state's motion, ASD, OCD, and DCD are either neurodevelopmental or neurobiological disorders as opposed to mental conditions caused by extreme physical factors or events. He notes that an MRI of defendant's brain shows objective evidence of disrupted brain structure in several nodes of the social network. Analysis. Idaho Code Section 18207 is not applicable. Section 18207 Idaho Code applies to any issue of mental condition in any legal proceeding at which the defendant's mental health condition may be an issue. It provides in relevant parts: 1. Mental condition shall not be a defense to any charge of criminal conduct. Nothing herein is intended to prevent the admission of expert evidence on the issue of any state of mind which is an element of the offense subject to the rules of evidence. Under the statute's evidence of mental condition is expressly permitted to rebut the state's evidence offered to prove criminal intent or mens rea. Any expert testimony admitted on this issue of mens rea or state of mind under Idaho Code Section 18207 must speak to an element of the crime. Here, however, defendant is not intending to use his diagnosis to challenge the state of the mind element of the crimes which he is charged. In fact, he is not intending to use his diagnosis as a reflection of his mental state at all, disputes that they are mental conditions in the first place. Thus, because defendant is seeking to introduce his diagnosis to explain physical deficits rather than mental deficits that qualify him from forming the intent necessary to commit the crime, 18207 does not govern. Having determined that Idaho Code Section 18207 does not apply, the next question is whether evidence of defendant's diagnosis is relevant. Evidence is relevant if it has any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. Rules of Evidence 401. Whether a fact is of consequence or material determined by its relationship to the legal theories presented by the parties. Even if relevant, the trial court has discretion to exclude the evidence if the probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considering of undue delay, waste of time, or needless presentation of cumulative evidence. Unfair prejudice is prejudice that tends to suggest a decision on an improper basis. With regard to evidence of his ASD, defendant contends it is relevant to explain that his ASD diagnosis is a physical condition and how it presents in his demeanor. Specifically, the defendant asserts testimony about his ASD will help the jury understand that his behavioral characteristics, such as his flat affect, intense eye contact, awkward body posture, and lack of emotive responses are associated with his ASD and should not be interpreted as a sinister light. The defendant argues he should be able to introduce this evidence at the outset of trial. The state responds that the defendant's demeanor is not a fact of consequence in this case and is not even evidence the jury can consider, at least if he does not testify. To this end, the state relies on a body of law regarding prosecutorial misconduct in commenting on the defendant's demeanor as evidence of guilt. In one representative case, United States v. Schuler, the court observed that a defendant's courtroom behavior off the witness stand is not admissible evidence and is legally irrelevant to the question of his guilt of the crime charged. Thus, in the absence of a curative instruction from the court, a prosecutor's comments on the defendant's off-the-stand behavior constitutes a violation of the due process clause of the Fifth Amendment. The clause encompasses the right not to be convicted except on the basis of evidence adduced at trial. While the relevance of defendant's demeanor is raised in a different context here, the principles of his body of law apply equally. The Supreme Court has declared that one accused of a crime is entitled to have his guilt or innocence determined solely on the basis of the evidence introduced at trial and not on grounds not adduced as proof at trial. The jury will be instructed as to what evidence is allowed to consider it in arriving at its determination of guilt or innocence, sworn testimony of witnesses, exhibits which have been admitted into evidence, and facts for which the parties have stipulated. A non-testifying party's demeanor is not included and therefore legally irrelevant to the question of guilt. While defendant cites the case law allowing evidence of ASD in the criminal context, those cases are distinguishable. In State v. Burr, which defendant predominantly relies upon, the New Jersey Supreme Court found evidence of the defendant's ASD was properly admitted in a child molestation case for two independent reasons. One, to explain that the defendant's actions of having his young piano students sit on his lap was not intended as a sexual grooming, but rather a way to relate to his students, and two, to educate the jury about the oddities in behavior the defendant might exhibit in court or that were described in the testimony of witnesses. These oddities and behaviors were not discussed in the opinion. However, in a prior decision by the New Jersey Supreme Court Appellate Division, the court provided more detail, thus placing the ruling in the proper context. There, the court noted that during a pretrial court appearance, the trial judge became alarmed by the defendant's odd appearance and demeanor, and he arrived to court with a bag of large sign draped over his head. When the trial judge inquired about the dress, the defendant began quoting from the book of Deuteronomy. Concerned, the trial judge ordered a competency evaluation, which revealed that the defendant was demonstrating signs of Asperger disorder, with which he was subsequently diagnosed. The state sought to exclude expert medical testimony at trial about the defendant's diagnosis, but the defendant argued it was relevant to show that his ability to make social judgments was impaired, allowing young female students to sit on his lap and to explain his odd or alarming appearances and mannerisms. The trial court excluded the evidence, and the defendant was convicted. Not one of defendant's experts has ever imputed behavior to him that remotely approaches the odd behavior in the Burr case. Moreover, the court has had the opportunity to observe defendants through multiple hearings over the past several months, some lasting all day. Not once has the court perceived defendants to be acting in an odd or incongruent manner or otherwise demonstrating signs at counsel table that would warrant an explanation to the jury. His demeanor has been entirely appropriate. In addition, unlike in Burr, the state has indicated it will not present any evidence from witnesses about defendants' alleged odd behavior. Consequently, testimony about defendant's ASD is simply not relevant if he does not testify. And it says defendant also cites to State v. Boyd in another case. None of these cases support the proposition that a defendant's ASD is relevant to explain courtroom demeanor of a non-testifying defendant. Rather, the evidence in each was used to rebut an element of the crime. Moreover, introducing such evidence risks confusing the issue, misleading the jurors, wasting time, and potentially unfair prejudicing both the defendant and the state. The jury will already be instructed about evidence it is allowed to consider in determining guilt, because there is no reason for the testimony except to explain something that a jury is not allowed to consider in the first place, i.e., defendant's demeanor. It may very well cause confusion about the role of the expert's testimony plays in the overall determination of guilt. While the court is not blind to the fact that the jury will be scrutinizing defendant's courtroom behavior during trial, allowing testimony about his ASD to explain his courtroom behavior amounts to judicial endorsement of improper evidence. If anything, presenting evidence of defendant's ASD will focus the jurors even more on the defendant's behavior that they likely would not have noticed in the first place. It may also diminish the weight assigned to the evidence the jury is instructed to consider in aiding in determination of guilt, despite instructions to the contrary. It essentially invites the jury to consider the character of the accused to determine guilt, which is not proper except as allowed by 404. In this sense, the evidence runs the risk of being unfairly prejudicial to defendant. In addition, it plays a risk into the jury's sympathies to the prejudice of the state. Moreover, expert testimony, particularly on a diagnosis as encompassing as ASD, will consume a significant amount of time in an already lengthy trial. Consequently, if defendant does not testify, evidence of his ASD to explain courtroom demeanor is inadmissible under 401 and 403. Then there's a footnote. Defendant's ASD can certainly be raised in voir dire, including questioning the jury panel about whether they can avoid judging the defendants improperly based on how he presents at counsel table, which may allay the defendant's concerns about how the jury may perceive him. And I told you, I thought that was totally proper to discuss in voir dire on previous shows that we talked about. I remember once I had a guy that had tattoos all over his head. We just discussed it in voir dire. Most people are like, yeah, don't care. If, however, defendant testifies, evidence to explain his demeanor may become relevant. At that point, the defendant's demeanor, which goes to his credibility, is relevant evidence a jury can consider, which the state concedes. However, prior to presenting testimony on the matter, the defendant must raise the matter with the court outside the presence of the jury to discuss the permissible scope. 2. The court reserves ruling on admissibility of OCD evidence. Defendant argues that the evidence of his physical manifestations of OCD may be relevant in rebuttal. Those manifestations, according to Dr. Orr, include compulsive hand washing, wearing gloves to avoid germs, and generally avoiding anything contaminated. The defendant further adds an argument only that his OCD causes sleep difficulties that has led to a habit of night driving and running to decompress. Dr. Orr noted in her report the defendant engages in self-soothing activities to decrease sensory inputs caused by his ASD, to include spending extensive time in the dark and driving. This was not linked to his OCD, however. He argues that if the state elicits testimony at trial related to the facts in order to support elements of the crime, evidence of these manifestations will be proper rebuttal. By way of example, he notes that just prior to his arrest, law enforcement saw him wearing gloves and handling baggies. Believing he was destroying evidence, law enforcement abbreviated its knock and announce procedures. If the state introduces this or similar evidence at trial, the defendant asserts that evidence of his OCD would be relevant rebuttal to offer another explanation of the behavior. The state responds that it does not intend to introduce any evidence during the guilt phase of the defendant's odd behaviors, social miscues, or other unusual behaviors. However, it requests that the court reserve ruling until the time of trial. The court finds this is an appropriate approach. Again, prior to introducing such evidence or otherwise mention it before the jury, the defendant shall raise the matter outside the presence of the jury. Evidence of OCD is not admissible to rebut ability to commit a crime. As with his OCD, defendant argues he intends to introduce evidence of deficits in his fine motor dexterity and visual motor functions caused by DCD to rebut the state's evidence that it was possible for him to have acted with the speed and coordination required to commit the crimes. The state responds that the defendant is improperly stretching the bounds of his expert's opinion to reach an inference that cannot reasonably be drawn, which was not disclosed and which otherwise has no support. It argued that the evidence is not relevant to guilt and or barred by Rules of Evidence 403. The state's challenge is well placed. Whether the defendant was physically capable of speed and dexterity to commit the crime on account of DCD is within the realm of expert opinion. As Dr. Lewine observed, DCD is characterized by impairments in the development of the motor coordination, including dexterity, limb speed, and gross and fine motor skills. It is associated with structural and functional disruptions of motor controls and coordinated networks with minimal modulation of psychological factors. However, it is not a diagnosis from which defendant currently suffers. In her report, Dr. Orr noted DCD was a diagnosis for which defendant met the criteria in the past. Further, there is nothing in her disclosure or report suggesting defendant was physically unable to commit the crime due to impairments associated with DCD. Her entire discussion on defendant's DCD is as follows. Defendant's educational history, parent report, and evaluation results all provide evidence that the defendant experienced significant deficits in motor functions in the course of development, which in turn contributed to the problems meeting physical, typical moto and coordination milestones of childhood. Examples: problems catching balls, handwriting, riding a bicycle. While motor problems have not impacted his functioning significantly in many years, defendant continues to present with impairment in fine motor dexterity and vulnerabilities in visual motor functions, evidence in his cognitive profile and observations of his behavior. The only observation Dr. Orr made with regard to the defendant's fine motor dexterity was that the defendant moved his whole arm and repositioned his upper body slightly to manipulate the items effectively. In her cognitive profile, she stated that defendant's visual motor skills were relatively weak in the context of his overall profile, particularly when precision or dexterity were involved. Copying visual motor sequencings, for example. Consistent with his history of fine motor deficits, when isolated, Bryan's fine motor dexterity and speed were impaired bilaterally, likely impacting his visual performances as well. The foregoing represents the extent of expert commentary on defendant's DCD. Nothing therein remotely approaches an opinion about defendant's ability to commit crimes. At most, Dr. Orr could testify about her observations about his weak fine motor dexterity and visual motor skills, but without any opinion tying this evidence to his ability to commit the crimes. Its relevance is lacking, and it invites unsupported speculation by the jury about the defendant's ability to commit the crime. Additionally, there is again the concern the expert testimony will consume an inordinate amount of time on an issue for which there is no foundation in trial that will already be lengthy. Weighing these concerns against the lack of the probative value further warrants its exclusion under 403 as the state of the evidence stands currently. So therefore, based upon the foregoing, the state's motion in limine regarding the neuropsychological and psychiatric evidence is granted in part and reserved in part. So we went over that, like I said, real quickly last time, but I think it was important to note, there's been all this talk that Bryan Kohberger was unable to commit the crimes because he has these deficits. He cannot physically have done this in any way. Well, even the defense's own experts say, yeah, that's not a thing. And although they may be able to say, yes, I saw some slight uncoordination, I guess you could maybe argue that at closing, but is certainly not going to be allowed to come in as an expert witness. So therefore, the defense did not fare well on that one. And it's a real tough argument to make. It'd be one thing if, for example, the case that was cited in the court's order where the guy had Asperger's and was just doing things completely inappropriate where the court grew concerned about it. At that point, you may be able to explain something away. But here you have a guy that maybe he has some quirks. Let's face it, don't we all have quirks? Of course we all do. His is he likes to wear gloves. Okay, that doesn't necessarily mean that he was destroying evidence. It just simply means he was trying not to, he was trying to avoid some sort of contamination. And so the police obviously didn't know that when they were, looking to arrest him at his parents' home. But his parents or family members may be able to testify to that. Yeah, he wears drugs. He's just got this thing. He just likes to, avoid anything gross and that could be contaminated. So cross-examination is, he's got this issues. He's got this issues. Detective, yeah, it wasn't really this. It's the classic. Sometimes things aren't always what they appear to be, right? And you can leave it at that and then save that for argument. All right, let's go ahead and get to the show today for Tuesday, April 22nd, 2025, the Bryan Kohberger case. Yes, the case that just keeps on giving. And I go back through and I look at the judge's orders and I'm telling you, the stage has been set. And it provides more insight as to where this case is going. First, the prosecution's case rests on several key pieces of evidence, right? And the judge's rulings have significantly shaped the trial. First, we got the DNA and the digital evidence, denied motions to suppress the DNA from the knife sheath, cell phone records, email data, surveillance footage, and Amazon purchase rulings allowing or ordering that they were all lawfully obtained under the search warrants and the third-party doctrine. And we got the roommate's testimony. The judge allowed in DM's testimony about seeing the masked man. The ruling issues should be addressed via cross-examination, not via exclusion. Then we have the autism diagnosis issue that the court ruled on, prohibiting the prosecution from mentioning any ASD type displays to explain demeanor unless Kohberger testifies, but allows the defense experts for rebuttal. And then, of course, we have the alibi as it relates to the nighttime drives. Is there really an alibi? Well, the judge is going to give him a little more time to come up with it, kind of like that third-party alternate suspect. You would think after 2.5 years, if there was a solid alibi, which we now know there is not, the defense would have put it out there. If there was a viable alternate suspect, that would have been presented long before now. The judge is still giving the defense a little more time to do so. But the reality of it is it doesn't exist, ladies and gentlemen. And of course, we had the ruling as it relates to the use of the terms touch DNA, contact DNA, and trace DNA, potentially limiting the prosecution's narratives. Now, the bulk of these rulings favor the prosecution, obviously admitting critical evidence while limiting defense strategies, particularly around Bryan Kohberger's various diagnoses. The DNA evidence, a pivotal piece is the DNA match from the leather knife sheath found next to Madison Mogen, with DNA from trash at Kohberger's family home in Pennsylvania. And obviously that is a big, big problem. And people can say, oh, it doesn't mean anything. It could be there. It could be whatever. The reality of it is unless you can say, and this is from, 30 years of criminal defense work. When one of my first big cases I ever did, I was still in the military, DNA was still just kind of coming about. We had hearings, whether it was even reliable enough to come in. And now obviously you don't even have those. It's been scientifically accepted by the courts, and they just lay the appropriate foundation. It comes in. But I've done lots of cases, including cold cases. And unless you can explain, and this is my experience as an attorney, unless you can explain how that got there through, i.e. consent, you would expect his DNA to be there because it was his house. It is a problem. And there's a lot of people that want to ignore this little piece of evidence. Oh, it doesn't matter how it could have got there. It could have been planted. Okay, prove it. How was it planted? Who planted it? And that's what people don't seem to get when it comes to this stuff. What I love about the true crime community is people are so engulfed in the case. But sometimes they pick sides and they ignore all the evidence. And like I said, I've said this before and I'll say it again. It doesn't matter what you believe. It only matters what you can prove through legal and competent evidence. So what evidence is going to come in to suggest that this was somebody else's knife sheath, or the knife sheath was Bryan Kohberger's, but it was stolen? And somehow the real killer planted it there just to frame Bryan Kohberger. You can make that argument. I could make that. I could stand up and do it right now. But the point is, what evidence do you have to back it up, ladies and gentlemen? That's not enough to raise reasonable doubt in this particular situation. DNA is the biggest problem for the defense. I've said this through this case has been going on. You have to be able to explain it. Because guess what? A random jury is going to look at this and the prosecution will argue, what are the odds that Bryan Kohberger's DNA just happened to be on a knife sheath that we know that he bought, that the sheath was there at the house with his DNA on it? And we also know that he may have tried to purchase yet another sheath. Can't just make that go away. And what are the odds, ladies and gentlemen, right? I think I've told you I've had this one since the summer of 1988 when I went to boot camp. 37 years, I guess it is. 37 years. I was able to hold on to and keep track of my K-bar for 37 years. And not your DNA wasn't on the little button, nor was mine. Bryan Kohberger's was. And it's to the point that the defense isn't even arguing about it. If the defense had an expert that was going to say, no, that DNA is not it, they've all but conceded the DNA is Bryan Kohberger's. So how are you going to get around that? It's going to be very, very difficult, ladies and gentlemen. And frankly, I'm not sure how that is actually going to take place for the defense. Then we have the eyewitness testimony, right? The surviving roommate, DM, described seeing somebody that she described as about 5'10" or taller, athletically built male with bushy eyebrows, dressed in all black mask the morning of the attack. Judge Hilper ruled this testimony is absolutely admissible, and that if there's any issues relating to the reliability of it, it can be addressed on cross-examination. Now, we've seen and heard in the court's orders what those summaries of the testimony was, and there's certainly things that you can attack about it, but if she didn't go out of her way, even after she had seen the arrest of Bryan Kohberger and said, oh yeah, that was the guy, it's definitely the guy. She's like, I don't know, I didn't see it. So that almost lends some credibility to it. Now, can a defense attorney have a heyday with that witness on the witness stand? Absolutely. It could be a brutal cross-examination if that's the way the defense wants to handle it. Or you just treat the witness with kid gloves and say, let's face it. It was dark. You were drunk. You were tipsy. You didn't know if you were awake. You didn't know if you were dreaming. Not a whole lot of reliability in that, right? And she may actually concede, you know what? It may not be reliable. I'm just telling you the general description that I have. And I added a couple of things, but I remembered it. It still goes to the credibility of the witness. We'll see. Then we have the surveillance footage, right? And vehicle evidence. The surveillance captures this white Hyundai Elantra near the crime scene, identified as Bryan Kohberger's, with his license plates changed 5 days post-murder. The car was found at his parents' home during the arrest, strengthening, obviously, the link that it is his particular car. Then we got phone records, right? They ping near the victim's residence there at 1122 King Road at least 12 times since June of 2022. Not saying he committed a murder on those particular times, but why was he there? Was he going to parties? Was he at that house all the time? Who knows? Did he carry a K-bar with him all those times? Did he lose it in the woods and somebody having to bring it into the house that night? Have to have good, reasonable explanations for this. And then we have the video, including twice on the murder day, the car was detected post-killings between 9:12 and 9:21 a.m. The judge allowed these recordings in, ruling them completely lawfully obtained. Then we have the Amazon purchase history, right? Records show Kohberger purchased this K-bar knife sheath and sharpener back in March of 2022 and searched for K-bar knives days after the murder. The defense sought to exclude this, arguing that the algorithm influence was improper, but the judge denied the motion, allowing it to come in, assuming the prosecution can lay the appropriate foundation. Then we got the selfie post-murder, selfie taken at 10:31 a.m. on November 13th. Showing Kohberger smiling and giving the old thumbs up. Obviously, it could be used to show his bushy eyebrows at or about the date of the murders. Maybe a state of mind thinking, I'm going to get away with this one. I mean, who did he send the picture to? He just happened to take a photo that particular morning saying, thumbs up. So obviously the evidence in favor of Kohberger's defense has presented limited direct evidence of innocence thus far, focusing more on obviously procedural challenges and an alibi, and then obviously the possible alternate suspect, which there's been no evidence, at least credible evidence, up to this date. Now, the alibi, Kohberger claims he was driving alone south of Pullman, Washington, and west of Moscow on November 13th to hike, to run, to check out the stars, a habit he often follows. Now, the defense, through their expert Cy wants to use this to corroborate this alleged alibi that the defense is trying to proffer, arguing his phone did not travel east towards the crime scene. However, the prosecution challenges this, and the judge's ruling haven't addressed its admissibility directly, but the cell phone records are more than likely coming in. And the defense theory, I mean, they can say it doesn't show that that his car moved further east because it was simple. It's simple because his phone was turned off. Obviously, the prosecution is going to argue because he thought he was going dark so that he could go commit these murders. Obviously, the defense sought to exclude the Amazon click history, arguing it could be taken out of context, and the roommate's description of the bushy eyebrows, claiming prejudice. Judge Hippler denied those motions, allowing these pieces of key evidence to come in. There are procedural arguments, not direct evidence of actual innocence. And then the whole autism spectrum disorder. Defense claims he has extreme rigid thinking and little insight into his behaviors, potentially affecting his demeanor in court. They argue executing him would violate the Eighth Amendment. However, the judge ruled the evidence is completely irrelevant unless Kohberger testifies, limiting its use in the guilt phase of the process. Ladies and gentlemen, the stage has been set. It's getting good. I keep looking at these rulings. And we'll give Bryan Kohberger the presumption of innocence. But the defense, although they don't have to prove anything, they have to be able to explain away why something was there, right? Oh, Bryan Kohberger went to this house all the time for parties. Nope, zero evidence of that. The knife sheath wasn't his DNA. Nope, they've all but conceded it's his DNA. This is a death penalty case, ladies and gentlemen. The attorneys are going into death mode. They've basically are conceding that they don't have a whole lot for trial. They're doing what they can, but this is now going into mitigation mode, trying to convince the prosecution to drop the death penalty. We'll keep you informed as it becomes available. April 23rd, 2025. And first, on the Bryan Kohberger matter, what is the big secret? All right, we told you the other day that the defense filed their proposed jury instructions under seal. Then the state says, well, we're going to respond to the state's sealing of their proposed jury instructions because, well, they filed it under seal, so therefore we will as well. And then the judge issued an order that says, based upon the state's motion to seal, the state's response to the defendant's proposed jury instructions filed, the court does hereby confirm and order that it is exempt from disclosure and sealed. What is the big deal, ladies and gentlemen? I don't get this. All right, let's quickly talk about jury instructions. I have here, this is what they call the Colorado Jury Instructions Criminal. Okay, the jury instructions have developed over many years. And then finally somebody got smart enough and said, hey, why don't we do these all the same and we'll put them all in a book. And we'll even, you can download them. You can go to the website. You can do what you need to do with it so that the judges have them and everybody's working for them. There's a committee of judges and non-judges, attorneys that go through and say, this is what the elements are. These are the instructions that we like based upon case law or what the legislature has done. And like I said, it's a 2-book volume, right? You get all the introductory responses, right? You hear all the judges read everything that sounds so well polished. Well, they're cutting and pasting it, ladies and gentlemen. So all the jury instructions are pretty much standard, right? orientation when you first show up, culpable mental state. Then we go through all the offenses. You can get the jury instructions for, let's just start, culpability based upon behavior of another, crimes of violence, sentencing enhancement, interrogatories, murder, manslaughter, homicide, assault, similar offenses, kidnapping and related offenses, unlawful sexual behavior, human trafficking and slavery, stalking, other offenses against pregnant women, arson, burglary, robbery, theft, trespass, theft of sound recordings, you name it. If there's a crime for it, they come up with it. All right. All the presumption of innocence types of things, all the definitions, if they're not defined in the statute, and they're meant to be, they are in the jury instructions. There's no secret, ladies and gentlemen. So I don't get, what is the big secret that the defense says we are proposing these jury instructions? First of all, they're 4 months out from trial. All right. Trial is supposed to start in August. I could submit any potential jury instruction that I wanted, but it would all be subject to the evidence at trial as to whether you actually get the jury instruction. Say, for example, I want to submit a self-defense instruction. I may not think that it's a good self-defense instruction in the sense that I think I'm going to get it, but I'm going to put it out there because I have to list my possible defenses, right? So if I was Bryan Kohberger's attorneys, of course, I'd say, well, I got an alibi, right? Then I would say, I didn't do it, but if I did, it was self-defense. And maybe then I'd include lesser included offenses that, wasn't a burglary. I didn't go in there, with the intent to commit a crime therein. All those different theories. It means nothing, though, unless and until the evidence comes out. So let's say, for example, I have a case where I want to have an affirmative defense of self-defense. The only way I get that evidence is if normally the defendant gets up and testifies and said, yeah, I was there. Guy came at me. I was in fear of death or serious bodily injury, and therefore I fired the gun and, killed the deceased. Okay. I would be entitled to that jury instruction. But if there's no evidence of self-defense, you don't get the instruction. And you must present a mere scintilla of evidence to be able to get the instruction. All right. All the instructions come from the standard books. I don't understand what's the big secret. All right. Now, there's a thing that can be submitted at the end of the trial. Okay. And it's called a defense theory of the case. And most judges will say, I don't want it unless you decide you want to give it. And you don't have to really give that until literally the case is over. I'm not a big fan of the theory of case defense because, by gosh, if the jury doesn't know what my theory and theme is by the time we get to jury instructions, I've probably done something wrong, right? If you can't figure out, ladies and gentlemen, this is a case about self-defense. By the time we get there, you don't need it in writing saying this is the defense theory of the case is that he acted in self-defense. Ridiculous, in my humble opinion. The only other thing I could possibly think of what the big secret is that the defense is trying to submit a bunch of instructions, trying to negate a mental state based upon some of these various characteristics that the court has said are not relevant as it relates to his autism, various other quirks that he may have. I don't see why or how that comes into play. Even if we're talking about instructions in the Bryan Kohberger case, not just the standard stock instructions, but like death penalty instructions about the mitigating and aggravating factors that the jury has to consider, they're all standard in the book anyway. Every state's got one of these as well. It used to be they wouldn't update these for like 5 or 10 years, but now they update them every year. I get a new book, and for some reason we get 2 or 3 copies every year because, well, we have multiple attorneys in here. We want to make sure you have it, but now all the young attorneys access them on the internet. So I guess I just don't understand what is the big deal so that now the defendant's proposed jury instructions are super, super secret, as well as the state's response is super secret just because the defense was. I think we'll hopefully be able to see this rather quickly. The judge will rule on it, and the judge's ruling is going to say, well, these are great. Other than standard instructions, we'll wait and see how the evidence comes out at trial. I just don't get what the big secret is. I swear, you go to any other court file in America, and if you want to see what's been filed, you should be able to have access to it. I don't know what the heck you guys are doing there in Idaho, but you think everything you do is super, super secret, and I just don't get it. And then when it gets released, it's no big deal. At least the Judge Hippler in this case, has been much, much better than, for example, Judge Woods or the judge in the Lori Vallow and Chad Daybell case, where I've never seen anything like that, where the case was literally tried in secrecy. The record today for April 24th, 2025. And yes, witness lists in the Bryan Kohberger case. But wait, are we going to get to see the witness lists? No. Why? Because they have been sealed. Let's take a look here. The prosecution filed a couple of new documents today. Notice of compliance and motion to seal state's witness and exhibit lists. Comes now, the state of Idaho, by and through the Latah County prosecuting attorney, and hereby moves and provides notice that the state has hand-delivered proposed exhibit lists, copies of exhibits, and proposed guilt phase witness lists to defense counsel pursuant to the court's October 8th, 2024 unredacted sealed ordering governing further criminal proceedings and notice of trial setting. Now, of course, that order is sealed, so we don't get to see it either. But the court's case management order, trial management order, whatever they call it in Idaho specifically here. But the reality of it is that's everything the court imposes. These are the deadlines and you must comply. If you don't comply, you could have deemed waived anything that should have been done. So we know the prosecution. Now, don't get me wrong. This is a big case and it's going to last a long time. Yes, the prosecution probably already has this. But normally, prosecutors aren't made to turn over their witness lists until maybe 7 days before trial. You know, you have a witness list, and that's the other thing. Normally, what takes place is you get a list of witnesses. And if that list of witnesses is updated, it's a public filing as to who is going to be a witness in the case. But remember, we are dealing with Idaho as well. So we got that. And then the court finally signed the orders sealing the requested jury instructions, order sealing phase 1 witness lists. Anyway, this is the defense also had to turn over their phase 1 witness list, which is kind of their general witness list. And then as we get closer to trial, there will have to be a good faith witness list. Who are you really going to call? We understand you have endorsed everybody under the sun because you have to, but who are you really going to call? Now, remember, the defense never has to do anything at trial, but if you are going to call any witnesses at trial, you have to endorse them. You have to say, here's the witness's name, their address and phone number if you know of them, and then they will be or should be made available for interview by the prosecutor. Now, the prosecutor cannot make a witness speak with them, but certainly it gets a little hay on cross-examination when you say, oh, you wouldn't talk with us? What are you hiding? That type of negative inference. Now, the police in the case obviously could speak with the defense attorneys and their investigators if they wanted to, but they won't. But you never know. Sometimes it's fun to ask to do that. Sometimes it's even more fun when you interview their expert witnesses. And so, I don't know. Hopefully the court will let us see who their good faith witness list is at some point. Then they had motions to seal, and then the motion to seal the defendant's phase 1's witness list. So there you go. Everything's sealed yet again, and I don't get it. I mean, I understand the prosecution. We don't want any people being intimidated, influenced, not wanting to testify, things along those lines. But we generally know who it's going to be. All right. And nobody should harass a witness in a criminal case. That's just a no-no. Part of the justice system is that people come to court. They testify under oath, under the pains and penalties of perjury if they were to give false testimony. That's part of our system. We don't want people not to show up. We want them to show up so that the truth comes out. That's what happens in an adversarial system. But the reality of it is, there's always going to be some knucklehead out there that's going to do something stupid and go and try to intimidate or dox a particular witness. And here, there's no reason to. All you have to do to go to court is show up and tell the truth. Well, maybe one of these days we'll get to see who the witnesses are soon before we have to actually wait for the trial to commence.